Using government employees for personal work impermissible, according to Madras High Court. For further information, we shall go to inside the video. I kindly request all the viewers to watch this small video in full. Now we shall move to inside the video. The Madurai Bench of the Madras High Court recently took strong exception to the use of government employees by higher officials in the police or prison department for personal work. P. Vadivel versus the Deputy Inspector General of Prisons. Justice SM Subramaniam directed the Principal Secretary of the Home Department to initiate all appropriate steps to issue directions to prevent higher officials from using public servants for their personal work in their residence or outside. The attitude or conduct is also a misconduct under the rules, and therefore the higher officials are expected to bear in mind that excess usage of public servants for their personal usage is impermissible and that will lead to indiscipline in the uniformed services, the judge said. The issue arose when the petitioner, a grade 2 warder at the central prison in Trichy, was transferred to Karur. However, pursuant to oral permission by the superintendent of prison Trichy, the petitioner continued in his official quarters for 3 months. The petitioner challenged an order of recovery of penal rent, submitting that he was performing the duty of the superintendent's driver and thus acted on his instructions and did not commit any irregularity. The court, however, found that after his transfer, any other duties assigned to him were of no avail for exonerating the petitioner from the payment of penal rent as per the rules in force. Any employee who is transferred is not eligible to retain the official quarters allotted to him beyond the period stipulated, the judge added. Justice Subramaniam further remarked that superior officials must also exercise restraint in such matters and should not utilize the services of a transferred employee for their personal convenience. Taking note of the large-scale allegations in the prison and the police departments that constables and head constables are abused by higher officials even for residential and personal work, the court said. Such a conduct of the higher officials can at no circumstances be appreciated but to be deprecated. It was stated that by virtue of higher position, subordinate officials are unable to refuse such services to the higher officials, resulting in deterioration of the departmental discipline. When the higher officials themselves are misusing the service of the public servants, then they cannot expect work discipline or good conduct from the subordinate officials. They too try to take undue advantage of the weaknesses of the higher officials, or they make an attempt to please these officials, the court held. Justice Subramaniam thus advised that the government must initiate all appropriate actions to ensure that such irregularities and illegalities are minimized to the extent possible, the order stated. The Inspector General of Prisons in this regard has to initiate all appropriate steps to ensure that the prison officials, namely superintendent of prisons or other higher officials, are not utilizing the service of the public servants for their personal usage. With these observations, the petition was dismissed. Hello viewers, from this video you may know the High Court directed the government to take all appropriate actions to ensure that such use of employees is minimized to the extent possible. If you are liking this video, means kindly press the like button as well as share to your friends and relatives. I kindly request all the viewers to subscribe this Aravindar and Arul channel. Moreover, I thank you for your valuable time spent for watching this video. Your response has been highly appreciated. Once again, thank you very much.